Hello, dear friends. In the 7th lecture on Erasmus Ecclesiastical Law, now we will speak about and will continue on subsystems of a multi-denominational state. This multi-tier structure is further grounded on agreements, as I have said already in my former lecture. This multi-tier structure is further grounded on agreements between certain states and the Holy See, and on conventions signed by their governments and particular religious communities. Thus, Germany has a concordat with the Holy See, as well as ecclesiastical conventions with Evangelical Lutheran Church and with other religious communities, enjoying the status of public law corporations. Hungary has signed international agreements with the Holy See and agreements with its 3 other historic churches. Italy has a treaty with the Holy See and 8 agreements with minority creeds that possess legal status by virtue of a special law. Spain has international agreements with the Holy See and 3 agreements with minority creeds that are deeply rooted in Spanish society. Croatia, Israel, Lithuania, Poland, Portugal, and the Slovak Republic all have international agreements with the Holy See. Luxembourg and Slovenia have agreements at the national level with the Catholic Church. Another criterion for differentiation of the legal treatment of the churches and religious community, that is, another criterion for a multi-tier structure, is the signing of agreements between the state and the Holy See and the state government and churches or religious communities. Now we can see how does this multi-tier structure is function taking the example of the Italian state. In Italy, on the top of the differential treatment, on the top of the pyramid of the different treatment of churches and religious societies, in the context of the subsystem of separation of a multi-denominational state, is found Catholic Church, with which the Italian state has concluded a treaty of 1984, through which the Lateran agreements have been modified. Lateran admittance of 1929 have been modified in 1984 through the Treaty of Villa Madama. Under the treatment of the Catholic Church in Italy is found the treatment of the eight churches or religious communities with which the state has which the government, the Italian government, has agreements. The agreements are concluded between, as it concerns the other churches or religious communities, are concluded between the government and the respective church or religious community. Under the treatment of the eight churches or religious communities with an agreement with the government, the churches or religious communities which have acquired legal personality under the special law on minorities of 1929, through which religious legal personalities acquired are found. That is on the third level. On the fourth level, the churches or religious communities with legal personality of civil codes are found. And on the fifth level of treatment, the churches or religious communities without legal personality are found. So we see a pyramid of different treatment of churches and religious communities in Italy. The same model of a pyramid of different treatment is found in each country, which has the subsystem of separation with a multi-denominational state. Now we'll pass to the system of separation of laicità, otherwise of positive state secularity. In this system of positive state secularity, that is of the Talaik, we found the same principles, the same constitutional principles found also in the subsystems of multi-denominational state with two differences. I remind the principles enumerated in the constitutional principles enumerated in the subsystems of multi-denominational state. That is, first, church and state separation. Second, state's multi-denominational nature. This is substituted by the state's positive state secularity, that is Talaik. Third, graduate equality through the differentiation of the legal regimes of the various creeds. this principle is also substituted by the more absolute equality of all the religious creeds. Third, the benevolent neutrality of the state, the same. A fifth, the church autonomy. So, the principles in the subsystems of multi-denominational state, separation with a multi-denominational state, and the principles in the system of separation with positive state secularity, that is Talaic, are the same if we change only the second one, that is the state's multi-denominational nature, by the Talaic, that is the positive state secularity, and if we substitute also the third principle of the graduate equality by the more absolute equality among all religious denominations. A Talaic or a positive state secularity means that a state, and concretely France, has the same treatment of all the churches or religious communities. And what is this same treatment of all church or religious communities? It is a very limited cooperation of the state with the churches or religious communities. Very limited means it gives very limited privileges. This is the meaning of the limited cooperation between church and state, and for all the religions, not only for some, as was the case of the extensive cooperation between church and state in the multi-denominational state system, where there was extensive cooperation, that is extensive concession of privileges only to some religions. Here, in the system of positive state secularity, that is Talaic, the state gives a few privileges. For example, no direct money grant to religions, but only indirect through tax exemptions, but to all religions. And the meaning of religious equality is not relative, that is gradual, as in the subsystem of separation of the multi-denominational state system, but the meaning of the equality in this system of separation of positive state secularity or Talaic is more absolute. But in two regions in France, that is in Alsace and Lorraine. The general statewide system of church-state relation does not apply here for historical reasons. Local law effectively maintains a multi-denominational state that officially recognizes four religious communities. In this district, the concordat between Napoleon Bonaparte and the Holy See is still in force. We can say that we have two countries which had as a model for church relation the French one, that is Russia and Turkey. As I have said already in a previous lecture, the Russian constitution guarantees état laïque, that is positive state secularity. But in practice, because of the agreements stipulated between different ministries of the Russian Federation and the respective departments of the Moscow Patriarchate, because of the symbolic meaning of the Orthodox Church of Russia for the Russian people, because of the actual policies of the Russian government, the Russian Orthodox Church, despite the constitutional system is of état laïque, the Russian Orthodox Church is a de facto an established church. And in Turkey, there is a contradiction in the same Turkish constitution because of the Kemalistic regime, which got valid in the past. But which still exists under a new form determined by the existing government. The Turkish state is, according to the Turkish constitution, a secular state. That is, it has the system of état laïque, of positive state secularity. But according to the same constitution, the office of the Prime Minister is responsible for the administration of the Muslim religion. The Turkish government through time imposes on each Muslim population a Sunni version of Islam. And as I have said, it fully administers Muslim religious affairs, despite the fact that the state follows the system according to the constitution of the positive state secularity that of a laïque. It insufficiently respects the autonomy of two of the three religious minorities that are recognized by the Treaty of Lausanne, and does not recognize the autonomy of any other religious minority. Now we have finished the general presentation of church and state relations in modern Europe, in the modern European countries. Now we'll pass to church and state relations, to religious freedom and church-state relations in the European countries with a predominantly Orthodox majority. And first, protecting the right to religious freedom and the principle of equality and non-discrimination on religious grounds. The right to religious freedom is guaranteed by the constitutions of the countries of the Orthodox cultural area. Orthodox cultural area means the countries, European countries with a predominantly Orthodox majority. The right to religious freedom is further developed by specific laws on religious freedom and the denominations regime in the following countries: Armenia, Belarus, Bosnia-Herzegovina, Bulgaria, Fyrom, Moldova, Romania, Russian Federation, and Serbia. Georgia, after recommendations from the United Nations Special Rapporteur for the freedom of religion or belief, amended in 2005 its civil code to allow for the registration of a denomination as a private law association. The principle of non-discrimination on religious grounds is also guaranteed by the constitutions of the states of Orthodox cultural area. However, the constitutional structure of two states, Cyprus and Bosnia-Herzegovina, is based on the religious discriminations favoring the political rights of major ethnic religious groups at the expense of the other religious groups. The 1960 Zurich-London treaties and the 1995 Dayton Treaty instituted for political reasons the 1960 Cyprus and the 1995 Bosnia-Herzegovina constitutions, respectively, not in compliance with international human rights law, that in enjoying all human rights demands full implementation of the principle of equality and non-discrimination on religious grounds by all domestic legislative acts, including the Constitution. By providing proportional representation at the House of Representatives, 70% of the deputies from the Greek community, and 30% of the Turkish community, and at the government, 7 Greek Orthodox ministers and 3 Turkish Muslim ministers. The Cyprus Constitution favors the Greek Orthodox and the Turkish Muslim communities. The Constitution of Bosnia-Herzegovina, also by providing equal representation of the constituent peoples at the House of Peoples of Parliamentary Assembly and the collective presidency of the Republic of Bosnia-Herzegovina, and equal representation of the Federation of Bosnia-Herzegovina and the Republika Srpska at the House of Representatives of Parliamentary Assembly, and the government of Republic of Bosnia-Herzegovina favors its 3 constituent peoples and institutes 2 entities. The constitutional difference in the religious discriminations between the 2 countries is the following. On the one hand, in Cyprus, 3 religious groups, Armenian Apostolic, Catholic Maronite, and Roman Catholic, are constitutionally recognized under the term religious group and have the constitutional rights as a group to choose one of the 2 communities to belong to it. It must be noted that they have chosen to belong to the Greek Orthodox community, while the members of the other religious groups have the right to choose community on an individual basis. In Bosnia-Herzegovina, on the other, a constitutional right of the religious groups to choose one of the constituent peoples to belong to is not provided for, while the members are citizens both of the Republic and one of its 2 entities at the same time. The constitutional difference between the 2 countries in allocating legislative jurisdiction on the denominational issues is that in Cyprus, on the one hand, that jurisdiction belongs exclusively to the 2 communal assemblies with regard to the respective communities, while in Bosnia-Herzegovina is shared between the Republic and the entities. The difference between the 2 countries in the function of the constitutional structure based on religious discriminations is the following. In Cyprus, the communal assemblies do not function de facto. The members of the Turkish community basically settled in the Turkey-occupied north part of the island after the 1974 military invasion. The de facto state power of the north part was self-declared in 1983 as the Turkish Republic of Northern Cyprus, recognized by Turkey and 2 other countries. The House of Representatives assumes the legislative powers of the Greek Communal Assembly. In Bosnia-Herzegovina, the system of constituent peoples and entities functions in an unhampered way so far. Now we have to finish our 7th lecture on Erasmus Ecclesiastical Law. Thank you very much for your attention.